The hearsay rule, statement of the rule. The federal rules define hearsay as a statement other than one made by the declarant while testifying at the current trial or hearing, often evidence to prove the truth of the matter asserted. If a statement is hearsay and no exception to the rule applies, the evidence must be excluded upon appropriate objection. The reason for excluding hearsay is that the adverse party was denied the opportunity to cross-examine the declarant. An out-of-court statement that incorporates other hearsay within it, hearsay within hearsay, or double hearsay, is admissible only if both the outer hearsay statement and the inner hearsay statement fall within an exception to the hearsay rule. Statement. For purposes of the hearsay rule, a statement is a person's 1. Oral or written assertion, or 2. Nonverbal conduct that intended as an assertion, for example, a nod of the head, offered to prove the truth of the matter. If the out-of-court statement is introduced for any purpose other than to prove the truth of the matter asserted, there is no need to cross-examine the declarant, so the statement is not hearsay. The following out-of-court statements are not hearsay. Verbal acts are legally operative facts. For example, words of contract, defamatory words, statements offered to show their effect on the listener or reader, for example, to prove notice in negligence case, and statements offered as circumstantial evidence of declarant's state of mind. The game's tied 7-7. Yeah. Do not confuse statements offered as circumstantial evidence of declarant's state of mind on the exam, which are most always offered as evidence of insanity or knowledge, with statements that reflect directly on the declarant's state of mind, which are usually offered to establish intent. The former is not hearsay, while the latter is hearsay, subject to a specific exception. In deciding whether evidence is hearsay, ask yourself whether you are relying on the declarant's credibility. For example, does it matter whether the declarant is telling the truth? If not, the evidence is not hearsay. Now, there's a little table here on the next page. I'm going to read it. It's a flow chart. It starts with, so basically answering yes or no to these questions is going to help you arrive at whether or not a piece of evidence is admissible. Is the evidence a statement for purposes of the hearsay rule? Is it an oral or written statement or conduct intended to be substitute for words? If no, it's admissible. Non-assertive conduct is not hearsay. Now, if you answered yes, you go further, inquiring, is the statement offered to prove the truth of the matter asserted? If no, it's admissible since it's not offered for the truth. The following are not hearsay. Verbal acts that unlegally operative facts, which we just said were words of contract or defamation. Statements offered to show effect on listener or reader, and example, notice or knowledge, and statements offered to show what the declarant believed to be true. However, if you answered yes, that the statement is offered to prove the truth of the matter asserted, then you proceed to the next inquiry. Is the statement a prior inconsistent statement given by the declarant under penalty of perjury? And if the answer is yes, it is admissible as non-hearsay. If the answer is no, you actually proceed to the next question in the hearsay decision flow. And the next question is the statement a prior consistent statement offered to rebut a charge that the witness is lying or exaggerating because of some motive, or 2, offered to rehabilitate a witness who has been impeached on some other ground, for example, other than a general attack on the witness's character for truthfulness. And if the answer to that inquiry is a statement of prior consistent statement for those purposes, the answer is yes, it's admissible non-hearsay. If the answer is no, you follow further along the decision tree to ask, and I have written here, agency admission. So is the statement one of identification of a person as someone the witness perceived earlier? If yes, it's admissible non-hearsay. If no, then you ask if it's an agency admission, which is phrased as was the statement made or adopted by a party to the action, or by a spokesperson authorized to speak on her behalf, two, her agent concerning a matter within the scope of the agency, three, her partner within the scope of partnership business, four, her co-conspirator in furtherance with the conspiracy, or five, her privy in title. And that's the question. It's like contains all the points of agency admission or adoptive admission. It looks like I didn't know which way to go with this. And kind of relevant to know probably all the potential types. So I'm going to read that once more. So you have the spokesperson and the co-conspirator, which is already written here. Spokesperson. And I'm writing authorized. And then there's agent, partner. These come with a sense of authority. Co-conspirator in furtherance of a conspiracy. So that's a vicarious admission. So the other vicarious admissions are admission by co-party, employer, employee, and partners. Or her privy in title, state courts. I don't know where that would go, so I'm just going to write it between the two topics of vicarious admissions and adoptive admissions. Privity in title, which then in parentheses says state courts. Now, if the answer is that the statement was made or adopted by the party, then it's admissible non-hearsay. But if no, it's hearsay, admissible unless one of the hearsay exceptions applies, which we're going to get to. On this page, yeah. Human declarations. There is no such thing as an animal or machine. Hearsay, there must be an out-of-court statement by a person. Thus, testimony about what a radar gun said and what a drug-sniffing dog did is not hearsay, but still must be relevant and authenticated if admitted. Statements that are not hearsay under the federal rules. Despite meeting the common law definition of hearsay, the following statements are not hearsay under the federal rules and are therefore admissible as substantive evidence. We're going to go out soon, don't worry. Let me just see how many pages I have. Prior statement is inconsistent. Prior statement of a testifying witness who subject to cross-examination is not hearsay if the prior statement is inconsistent and the declarant's in-court testimony and was given under penalty of perjury at the prior proceeding. A prior statement is consistent with the declarant's not in-court testimony and is offered to rebut a charge that the witness is lying or exaggerating. I just read all this. Because of some motive in the statement being offered, before any motive to lie or exaggerate arose, or two, to rehabilitate on some other ground. And third, the prior statement is one of identification of a person as someone the witness perceived earlier, even if the witness cannot remember the identification. And statements by or attributable to an opposing party. This is the admissions by party opponent. An opposing party statement, i.e. any statement made by a party and offered against that party, is not hearsay under the federal rules. These statements are traditionally called admissions of a party opponent. To be an admission, the statement need not have been against the declarant's interest when made, and may even be in the form of an opinion. Personal knowledge is not required. The admission may be predicated on hearsay. The following types of admissions merit special attention: judicial and extrajudicial admissions. Formal judicial admissions, pleading stipulations are conclusive. Informal judicial admissions made during testimony and extrajudicial evidentiary admissions are not conclusive and can be explained. Adoptive admissions. A party may make an admission by expressly or impliedly adopting or acquiescing in the statement of another. Silence. If a reasonable person would have responded and the party remained silent in the face of accusatory statements, his silence may be considered an implied admission. Since silence is treated as an admission only when the party can hear and understand the statement, the party was physically and mentally capable of denying the statement, and a reasonable person would have denied the accusation. So I'm just going to mark silence here in its own little section, because those factors, they're not hard to remember. So 1, heard and understood. 2, capable of denying. And 3, I'm just writing reason because a reasonable person would have denied under those circumstances. Note that silence in the face of accusations by police in a criminal case is almost never considered an admission of a crime. Vicarious admissions. And here you have the co-parties, the authorized spokesperson, the principal agent, the partners, the co-conspirators, privies and title, and joint tenants in state courts only, and preliminary determinations. That's on page 37. I am looking at this outline being another, how many pages? 51. In this recording, we're at 13 minutes already. All right, so vicarious admissions, co-parties, insufficient relationship. Statements of a party are not receivable against her co-parties merely because they happen to be joined as parties. Authorized spokesmanship. So this is not receivable against a co-party. That's weird. But it's quoted by case law, but in actuality, it's really hard to do. That's why most cases are separate. You don't usually see people that are true co-parties anymore. Authorized spokesperson. A statement of a person authorized by a party to speak on its behalf. Example, statement by a company's press agent can be admitted against the party as an admission. Principal agent. Statements by an agent or employee concerning any matter within the scope of her agency or employment made while the agency or employment relationship exists are not hearsay and are admissible against the principal. Partners. After a partnership is shown to exist, the admission of one partner relating to matters within the scope of a partnership business is binding upon her co-partners. So you have to have a showing of a partnership. Co-conspirators. Admissions of one conspirator made to a third party in furtherance of a commission to commit a crime or civil wrong at the time when the declarant was participating in the conspiracy are admissions against co-conspirators. Under the federal rules, the court must use the co-conspirator statement itself, together with other evidence, to determine whether the statement is admissible. For example, the proponent is not limited only to independent evidence to show that the conspiracy existed and that the declarant and party were participants. Privies in title and joint tenants, state courts only. In most state courts, admissions are either joint owners or admissible against the other. The admission of a former owner of real property made at the time she held title are admissible against those claiming under her, grantees, heirs, etc. These statements are not considered admissions under the federal rules, but may be admissible under one of the other hearsay exceptions. So I'm guessing co-conspirator is not automatic. I think that's one. Not automatically admitted. And that whole Title I, privity and title, this is also like not admissions. So why is it even here? Preliminary determinations. Before admitting a hearsay statement of vicarious admission, the court must make a preliminary determination of the party, declarant's relationship with the party against whom the statement is offered. In making such a determination, the court must consider the contents of the statement, but the statement alone is not sufficient to establish the required relationship. Hearsay exceptions. Declarant unavailable. There are 5 reported exceptions to the hearsay rule that condition admissibility of the hearsay statement on the present unavailability of the declarant to testify. So these are your unavailability exceptions to hearsay rule. The declarant is unavailable if he, and this is the PRISM mnemonic. PRISM is privilege, refusal to testify, insufficient memory, sickness, and absence. Or missing, right? I think. So what is unavailability? Unavailability is uses the PRISM mnemonic of privilege exists, refusal, insufficient memory, sickness, death, and missing, absence. Right? Shall I read what all of those things mean? Is exempt from testifying because of a privilege, refuses to testify concerning the statement despite a court order, testifies that he does not remember the subject matter, is unable to testify due to death or physical or mental illness, or is absent and the proponent is unable to procure his attendance or testimony by process or other reasonable means. A declarant who is able to give deposition testimony in lieu of attending is considered to be an available witness. Except with respect to the former testimony and forfeiture by wrongdoing, exceptions discussed in 2 and 6. Former testimony, the testimony of a now unavailable witness, is admissible if 2 things. 1, the testimony was given under oath at earlier proceeding, and in the same case, and 2, the party against whom the testimony is now being offered in a civil case, the party's predecessor in interest includes the grantor, grantee, or other privity relationships, had an opportunity or similar motive to develop the declarant's testimony at the prior proceeding by direct cross or redirect examination. So the party against whom the former testimony is being offered, right, or privity. One, I'll just write opportunity to examine. Wait, declaring. So, on a practical level, the opportunity and similar motive requirement means that the opportunity and similar motive. That's kind of the operating words. What does that mean? That requirement means that the party against whom the testimony is offered or her predecessor in interest must have been a party in the former action, and the former action must have involved the same subject matter and causes of subject matter. But the cause of action need not be identical. Okay, so another exam tip is because a grand jury proceeding does not provide the accused with the opportunity for cross-examination, the grand jury testimony of an unavailable declarant is not admissible against a defendant under the former testimony exception to the hearsay rule. Be careful not to confuse this with a prior consistent statement given under oath by a witness currently testifying. Grand jury testimony of an unavailable declarant is not admissible against a defendant under the former testimony exception of the hearsay rule. Be careful not to confuse this with a prior inconsistent statement given under oath by a witness currently testifying. Grand jury testimony is admissible in that case both as admission and as substantive evidence. Statements made against interest. A statement of a person now unavailable as a witness may be admissible if it was against that person's pecuniary, proprietary, or penal interest when made, such that a reasonable person in the declarant's position would have made it only if she believed it to be true. The declarant must also have had personal knowledge of the facts and must have been aware that the statement was against her interest when she made it. Statement subjecting declarant to criminal liability. In criminal cases, the federal rules require corroborating circumstances indicating the trustworthiness of statements against penal interest. Statement means single remark. If a person makes a declaration containing statements that are against his interest, I sold the drugs, the statements that are not, example, X runs a drug ring, the exception covers only those remarks that inculpate the declarant, not the entire extended declaration. So, thing to remember is the pecuniary, proprietary, or penal interest when made. Got it? Pecuniary, again, the statement against the pecuniary, proprietary, penal interest when made. So statements by an opposing party versus statements against interest. What's the difference? For statements by an opposing party, statement need not have been against interest when made. Declarant need not have personal knowledge of facts. Declarant need not be unavailable, and declarant must be a party. Whereas statements against interest, a statement must have been against interest when made. Declarant must have personal knowledge of facts. Declarant must be unavailable, and declarant need not be a party. So, I might put that one on the wall, only because I struggle a lot with this quote statements by opposing party. I feel like I just need some examples because I mean, it's got to be a party, but when was it made? And like, how is it hearsay? They need not be unavailable. So I don't know. I don't see it here. I don't know if it's not part of the federal rules anymore, but I get really thrown by that one. So I'm going to put this one on the wall. Dying declarations, statements under belief of impending death. In a homicide prosecution or in any civil action, a statement made by a now unavailable declarant is admissible if the declarant believed his death was imminent, he need not actually die, and the statement concerned the cause or circumstances of what he believed to be his impending death. Note that the statement must be based on the declarant's perceptions and firsthand knowledge of what happened. For example, an unsupported opinion or speculation will not qualify. A bar exam may require you to distinguish the federal rule on dying declarations from the traditional rule. Beware of answer choices reflecting the traditional rule, which 1, require that the declarant ultimately die of the injury, and 2, cannot be used in civil cases. Okay, so dying declarations. What does it require? Homicide. It can now be, I guess, what I just read is criminal or civil. I don't know when that changed. The declarant believed death was imminent, and 2, statement concerned cause or circumstances. And here's 2 exam tips. The bar exam may require you to distinguish the federal rule on dying declarations from the traditional rule. I already read that, where the declarant ultimately had to die of the injury and it could not be used in civil cases. Exam tip: remember, although the dying declaration exception may be used in civil case, its use in criminal cases is restricted to homicide prosecutions. There is no dying declaration prosecutions for attempted homicide. Right. And statements of personal. So now I have 11 pages left. I only got through 3. Is that okay to finish this? Okay. Statements of personal and family history. Statements by a now unavailable declarant concerning births, marriages, divorces, relationship, gynecological status. Example are admissible prove that the declarant is a member of the family in question or intimately associated with it, and the statements are based on the declarant's personal knowledge of the facts or her knowledge of the family reputation. Statements offered against party procuring declarant's unavailability. The statement of a person now unavailable as a witness is admissible when offered against a party who has engaged or acquiesced in wrongdoing and intentionally procured the declarant's unavailability. So the hearsay exceptions when unavailability is required are former testimony, statements against interest, dying declaration, statement of personal or family history, and statement offered against party procuring declarant's unavailability. And there's a short definition for each. Former testimony, we talked about statement made under oath at the time or at other proceeding at which the party against whom it is offered had motive and opportunity to develop testimony. Statement against interest, statement against declarant's pecuniary, proprietary, or penal interest when made. Statement made while declarant believed death was imminent concerning the cause or circumstances of impending death. statement of personal or family history, birth, death, marriage made by family member or one intimately associated with the family, and statement against offered against party procuring declarant's inavailability. The statement of unavailable declarant offered against a party who intentionally procured the declarant's unavailability is simple as it sounds. Hearsay exceptions: declarant's unavailability is immaterial. The following exceptions to hearsay rule do not require that declarant be unavailable: excited utterances, an out-of-court statement relating to a startling event made while under the stress of the excitement from the event. For example, the declarant had time to reflect upon it, is admissible. Sometimes a failed dying declaration may succeed in an excited utterance, for example, where the declarant is available or had some hope of survival. Present sense impressions. Present sense impression is a statement that describes or explains an event or condition and is made while or immediately after the declarant perceives the event or condition. There is little time for calculated misstatement, and the contemporaneous nature of the statement makes it reliable. Excited utterances versus present sense impression. The excited utterance must relate to a startling event, and the statement must be made while still under the stress and excitement of the event. But in present sense impressions, a statement must describe or explain an event or condition. The event or condition need not be startling, and the statement must be made while or immediately after perceiving the event or condition. Strict timing requirement, which I think is even more strict in California. It must be like concurrent. So the excited utterance and present sense impression exceptions sometimes overlap. If a statement in an essay fact pattern appears to meet requirements of both exceptions, go ahead and analyze the statement under both of them. You don't need to pick just one. Present state of mind. The statement of the declarant's then existing state of mind, motive, intent, or plan, or emotional, sensory, or physical condition is admissible. It is usually offered to establish a person's intent or as circumstantial evidence that the intent was carried out. Except as to certain facts concerning the declarant's will, however, a statement of memory or belief is not admissible to prove the truth of the fact remembered or believed. Declarations of physical condition. There are two hearsay exceptions involving statements of physical condition. Statements of the declarant's present physical condition, regardless of the purpose for which the statement is made, and two statements made for the purpose of obtaining medical diagnosis or treatment. Declarant's present bodily condition. A spontaneous declaration of declarant's own present bodily condition is admissible as an exception to the hearsay rule, regardless of whether it was made for the purpose of diagnosis or treatment. On page 42, statements made for diagnosis or treatment includes past conditions. A statement that describes a person's medical history, past or present symptoms, or their inception or general cause is admissible as an exception to the hearsay rule if it was made for and was reasonably pertinent to medical diagnosis or treatment. Usually, a declarant will be describing her own condition, but this is not required. For example, the declarant may be seeking medical assistance for a family member. Statements falling within this exception are usually made to medical personnel, but this is not an absolute requirement. Exam tip: if a declarant tells an emergency room physician, "I was stabbed with a kitchen knife, my roommate did it," only the first portion of the statement is pertinent to diagnosis or treatment. Note, however, that many federal courts will admit a statement in which a child abuse victim identifies the abuser in the course of treatment. Remember that, contrary to the majority state view, declarations of past physical condition made to a doctor employed to testify are admissible under the federal rules. Records of regularly conducted activity, business records, any writing or record made as a memorandum of any act or transaction is admissible in evidence as proof of that act or transaction. Under the federal rules and modern statutes, the main requirement for admissibility are as follows. Note, however, that under the federal rules, even an otherwise qualifying business record may be excluded by the court if the opponent makes a showing that the circumstances of the writing indicate a lack of trustworthiness. Business includes every business organization, occupation, or calling, whether or not for profit. So why doesn't it have the elements here? Entry made, I guess the elements are entry made in regular course of business, after defining business, and personal knowledge. So it needs to be consists of matters within the personal knowledge of an entrant or within the knowledge of someone with the duty to transmit such matters to the entrant. So there's like an authentication or a foundation that has to be laid by someone with personal knowledge of this business record. So to be admissible, it must appear that the record was made in the course of a regularly conducted business activity, and that it was customary to make the type of entry involved. The entrant had a duty to make an entry. Self-serving accident reports prepared primarily for litigation usually are inadmissible, and generally police reports are not admissible against a criminal defendant under the business record exception. Personal knowledge. The business record must consist of matters within the personal knowledge of the entrant. Someone with the duty to transmit matters to the entrant. Exam tip: business records often present a multiple hearsay problem. Watch for fact patterns involving police reports or other incident reports that contain statements from bystanders who generally are not under a business duty to convey information to the police. Although the report itself, the outer hearsay, the entrant's assertion that the bystanders made these statements may qualify as a business record, the bystander's statement within it, the inner hearsay, do not and will need to fall within some independent hearsay exception or exclusion statement by opposing party, for example, of an exclusion. On the other hand, if the report merely contains the entrant's own observations or statements of persons under a business duty to report the information, the entire report may be admissible under the business records exception. Page 43. Entry made near time of event. An entry must be made at or near the time of the transaction. Authentication. The authenticity of a record must be established. This can be accomplished by the custodian testifying that the record is a business record or certifying in writing that the record is a business record. So I had to write some of this down. Unless it's already written down somewhere. This business record one comes up a bit. Business defined, entry made in regular course of business, personal knowledge of entrant or duty, right, of entrant or duty on entrant to transmit, and then entry made contemporaneous to the event, and authentication which testifies, the custodian testifies and certifies or certifies in writing. I'm just going to write to authenticity, but it says that a record is a business record. Okay. Reported recollection. Business records may be used to prove the non-concurrence or non-existence of a matter if it was the regular practice of the business to record all such matters. Reported recollection. If a testifying witness's memory cannot be revived, a party may introduce a memorandum that the witness made or adopted at or near the time of the event. For admissibility requirements, see a later section. The record itself is not received by the jury as an exhibit. It must be read to the jury. Official records and other official writings. That was the recorded recollection. That no longer was a business record exception, but we already wrote that down. They can't remember. The memory can't be revived. The party may introduce a memorandum that the witness made or adopted near time of the event. Now, official records are other official writings. You have public records and reports, and records of vital statistics, statements of absence of public record, and are they all here? They get summed up pretty nicely here in records and reports of public agencies regarding their activities and records of births, deaths, or marriages, etc. Absence of record is admissible to show non-existence of a matter. So does that cover that whole section? Records of vital statistics are admissible if reported to a public office in accordance with the legal duty. And so the absence, a statement of absence of a public record is enough to show, is admissible to show that something probably didn't happen. If it's of the type it would regularly be. So person diligently searched and failed to find a record is admissible to prove the record was not recorded, or inferentially that the matter did not occur. You have the right to confront and may demand the presence of a person who prepared the certification. This type of evidence is admissible in the form of certification only if the prosecution notifies the defense at least 14 days before the trial and the defense does not object in writing within 7 days of receiving the notice. Judgments. A certified copy of a judgment is always admissible proof that such judgment has been entered. So a copy of a judgment of a prior felony conviction is admissible to prove the facts essential to the judgment. In a criminal case, it may be used for the purpose only against the accused. So that's what it says in the summary section, but this is broken into 3 sections. Prior criminal conviction, felony conviction admissible. Prior criminal acquittal is excluded. The exclusionary rule is still applied to records of prior acquittals and judgment in formal civil case. A civil judgment is clearly inadmissible in the subsequent criminal proceeding and generally inadmissible in the subsequent civil proceeding. Ancient documents, statements and authenticated documents prepared before January 1 of 1998, and documents affecting property interest, statements in a document affecting the interest in a property, for example, a deed, a will, and learned treaties. Treaties are admissible as substantive proof of the federal rule. Under the federal rules, if called to the attention of or relied on by expert witness and established as a reliable authority by the testimony of a witness, other expert testimony or judicial notice. Here it says statements from authoritative works admitted if called to attention of expert witness and established as reliable authority. Reputation, family records, market reports. Reputation evidence concerning a person's character, a person's personal or family history or land boundaries, or a community's general history is admissible under several exceptions. Those are them: character, personal family history, land boundaries, community's general history. Family records or statements of facts concerning a personal family history contained in family Bibles, jewelry, engravings, genealogies, tombstone engravings, etc. are admissible. Market reports are other published compilations generally used and relied upon by the public or by persons in a particular occupation. So there's a nice little summary table here of everything that we just went over that I'm going to hang on the wall, but I'll let it be on the screen while I read the back of the page. Residual catch-all exception in federal rules. For a hearsay statement that is not covered by a specific exception to be admitted, the federal rules provide a catch-all exception, which requires 1, that the hearsay statement possess circumstantial guarantees of trustworthiness, that the statement be strictly necessary, and that notice be given the adversary as to the nature of the statement. Constitutional issues under the Confrontation Clause. A hearsay statement will not be admitted even if it falls within a hearsay exception when 1, the statement is offered against the accused in a criminal case, 2, the declarant is unavailable, 3, the statement was testimonial in nature, and 4, the accused had no opportunity to cross-examine the declarant's testimonial statement prior to trial. However, the defendant forfeits his right of confrontation if he committed a wrongful act that was intended to keep the witness from testifying. And that one's really important. I feel like you need to write that down. Testimonial statement. Statements made in the course of police interrogations. Whether a statement made in response to police interrogations is testimonial depends on its primary purpose. To aid in ongoing emergency, not testimonial. If the primary purpose of a police interrogation is to enable the police to help in an ongoing emergency, statements made in the course of interrogation are non-testimonial. For example, 911 call during an ongoing crime. In determining whether an ongoing emergency existed at the time of the interrogation, relevant factors include the nature of the dispute, public or private, whether the perpetrator is still at large, third, the scope of the threat to the victim and to the public, and fourth, the type of weapon involved. To establish or prove events for later prosecution, that is somewhat the definition of testimonial. And so when the primary purpose of the interrogation is to establish or prove past events, like put together prosecution materials potentially relevant to a later criminal prosecution, statements are testimonial. Statements to the police describing a crime after it has concluded. On the other hand, statements by a young child abuse victim to a school teacher about the abuse are not testimonial because the primary purpose of the conversation is protection of the child, not prosecution of the perpetrator. Affidavits or written reports, forensic analysis. Affidavits, certificates, or other written reports that summarize the findings of forensic analysis and have the effect of accusing a targeted individual or criminal conduct. Example, fingerprint results are testimonial and may not be admitted unless the defendant previously had an opportunity to cross-examine the author of the report. The testimony of the analyst supervisor who was not involved in the testing is not sufficient to admit the results. However, such reports may be used for a non-hearsay purpose. Specifically, no confrontation or violation occurs if a forensic expert, while testifying as to her independent analysis of data, makes a general reference to a non-testifying analyst's report to demonstrate a partial basis for her opinion. Can you help me with something? Can you write down? Can you write something down for me? Actually, on the back page here, let's write down like pretty much like this whole thing on the back with the title too. But the title is just confrontation clause. And then also write down these factors from here down with under the title like ongoing emergency. Okay. Thanks. Moving right along on page 47 now, so there's only 4 more pages. Due process rights is something I also hang on the wall. Procedural considerations. So let's start with due process rights. Hearsay rules and other exclusionary rules cannot be applied where such application would deprive the accused of her right to a fair trial or deny her right to compulsory process. Admissible out-of-court statements. So this is an interesting table. You have basically a list of all 16 different types of hearsay exceptions that I talked about. 17 would be the residual catch-all. And they're like classified by non-hearsay or hearsay exceptions where unavailability is required or availability is immaterial. So just for one last attempt at like helping identify issues. For non-hearsay, you have non-assertive conduct, statement not offered for its truth, prior inconsistent statement made under oath, prior consistent statement offered to refute a charge that the witness is lying or exaggerating, prior consistent statement offered for any other ground that a witness was impeached to rehabilitate that witness, prior statement of identification, opposing party statement, including vicarious admission. So those are all non-hearsay. Where unavailability is required for a hearsay exception includes former testimony, dying declaration, statement against interest, statement of personal or family history, statement offered against party procuring declarant's unavailability. I wrote here forfeiture by wrongdoing under that and cited Giles versus California, but that where availability is immaterial to a hearsay exception, you have excited utterance, present sense impression, present state of mind, present physical condition, statement for medical diagnosis or treatment, reported recollection, business record, 1410. Business records or absence thereof, public records and reports, reports of vital statistics, judgments of prior convictions, ancient documents, documents affecting a property interest, learned treatises, and reputation, family records, and market reports. Next page is procedural considerations, and you have the burden of proof and presumptions. So the burden of proof encompasses the burden of producing or going forward with the evidence and the burden of persuasion. So there's two parts here. Burden of producing evidence. The party who has the burden of pleading usually has the burden of producing or going forward with evidence sufficient to make out a prima facie case, i.e. create a fact question of the issue for the trier of fact. I'm going to write on this. Once a party has satisfied the burden of going forward with the evidence, it is incumbent upon the other side to come forward with evidence to refute the accepted evidence. However, the burden of persuasion, it says here, proof, after the parties have sustained their burden of production of evidence, the question is whether the party with the burden of persuasion is satisfied. The burden of persuasion for civil cases is usually a preponderance of the evidence, more probably true than not true, although some civil cases require clear and convincing evidence, which is a high probability, which I believe is only more likely than not. And the burden of persuasion for criminal cases is beyond reasonable doubt, which is like pretty much 100% or 99% true. Presumptions. A presumption is a rule that requires a particular inference be drawn from an ascertained set of facts and is a form of substitute proof that in that proof of a presumed fact is rendered unnecessary once evidence has been introduced of the basic fact that gives rise to the presumption. So we have a couple examples here. I'm just going to read the names. Effect. It shifts the burden of production to the party against whom the presumption operates. It does not shift the burden of persuasion, just so you know. Rebuting a presumption is overcome or destroyed when the adversary produces some evidence contradicting the presumed fact. Once sufficient contrary evidence is admitted, the presumption is of no force or effect. Distinguish true presumptions from inferences and substantive law. True presumptions are a rebuttable type discussed above. Be careful not to confuse them with inferences or rules of substantive law. Permissible inferences may allow the party to meet his burden of production, establish a prima facie case, but does not shift the burden to the adversary. Examples include inference of negligence arising from re ipsa loquitur, inference that destroyed evidence is unfavorable to the spoliator, and the inference of undue influence when the will's drafter is also the principal beneficiary. Page 49. Presumptions in criminal cases is merely permissible inference. The burden of production never shifts to the accused. There's some exam tips here, just showing the difference between, like, the jury never has to accept a presumption in criminal, but may regard the basic fact as sufficient evidence of a presumed fact. And that's how they should be instructed. So if in a criminal case, a presumed fact establishes guilt, is an element of the offense, or negates the defense, it must be proved beyond reasonable doubt. Conclusive presumptions, because it cannot be rebutted, a conclusive presumption, for example, that a child under age 7 cannot commit a crime, is really a rule of substantive law. Specific presumptions are listed here. I'm not going to define them all, but legitimacy, against suicide, sanity, death from absence, ownership of car, which is like 7 years, continuous period, ownership of car, agent driver, proof of ownership of a motor vehicle creates the presumption that the owner was the driver or that the driver was the owner's agent. Chastity, regularity, continuance, mail delivery. A letter properly addressed, stamped, and mailed is presumed to have been delivered. Solvency, Bailey's negligence, and marriage, which is upon proof of a marriage ceremony, a marriage is presumed valid. Conflicting presumptions. When two or more conflicting presumptions arise, the judge should apply the presumption founded on the weightier considerations of policy and logic. Choice of law regarding presumptions in civil actions. Under the federal rules, state law governs the effect of a presumption concerning a fact that is an element of a claim or defense to which, under the Erie Doctrine, the rule of decision is supplied by state law. So lastly is the relationship of parties, judge, and jury. Allocation of responsibilities. In our adversarial adjudicative process, the focus is on the party's responsibility to frame the issues in the litigation and to assume the burden of proving the issues he has raised. The trial judge's primary responsibility is to superintend the trial fairly. As a general rule, decisions of law are for the trial judge to determine and questions of fact for the jury. Preliminary determinations of admissibility. Neutral. Preliminary determination of admissibility. In most cases, the existence of some preliminary or foundational fact is an essential condition to the admissibility of proffered evidence. The federal rules distinguish preliminary facts to be decided by the jury from those to be decided by the judge on the ground that the former questions involve the relevancy of the proffered evidence, while the latter questions involve the competency of evidence that is relevant. Preliminary facts decided by jury. Examples of preliminary facts are to be decided by the jury include agency, authenticity of a document, credibility of a witness, and personal knowledge. So those are preliminary facts to be decided by the jury. Those that are to be decided by the judge are facts affecting the competency of the evidence must be determined by the trial judge. Requirements for hearsay, exceptions, privileges, and expert testimony, as well as mental competence, must also be decided by a judge. What evidence may be considered? The federal rule permit the trial judge to consider any non-privileged relevant evidence, even though not otherwise admissible under the rules of evidence. Most state courts, however, hold that the rules of evidence apply in preliminary fact determinations as much as any other phase of the trial. Thus, only admissible evidence may be considered. And presence of the jury, whether a jury should be excused during the preliminary fact determination, is generally within the discretion of the trial judge. However, the jury must be excused if 1, the hearing involves the admissibility of a confession, or 2, the defendant is a criminal case, is testifying at the hearing, and requests that the jury be excused. And testimony by accused does not waive privilege against self-incrimination. An accused may testify on a preliminary matter, circumstances surrounding an allegedly illegal search without subjecting herself to testifying at trial. Okay, I don't know how, but on preliminary, okay. Judicial power to comment upon evidence. A judge may comment on the weight of the evidence in federal courts, but generally not in state courts. Power to call witnesses. A judge may call and interrogate witnesses on her own initiative. Rulings. A state court has an obligation to rule promptly on counsel's evidentiary obligations and upon request to state the grounds for her rulings. Instructions on limited admissibility of evidence. If evidence is admissible on a limited basis, the judge must, on timely request, restrict the evidence to its proper scope and instruct the jury accordingly. So that is going to be it for the latter part of BARBRI's CMR outline. This is, I think, maybe a different, it's definitely different. It's a little bit shorter than what was the reading yesterday, but it covers the same material.